March 2nd, 2024. Well, we're on the end of the Super Tuesday period here. Of course, where I am, I've already early voted and voted for Trump for president because, well, he's the only game in town, and he's a good guy, I guess you just have to say. But I wanted to, Haley, I think, is pretty well. She's still there for Super Tuesday, but I mean, after her poor performance in Michigan, I don't know where she's going to, show up and do a lot better. We'll see. But anyhow, so we're pretty well settled that I think Trump is going to be the nominee for sure, and have been for a little while actually. In fact, I was pretty sure of that before anything even started. But what we're discussing right now is the situation with all the trials. Now, of course, we have the overboard judgments in the two civil cases. And I guess the question is still left here, will he be able to raise enough money to pay so that he can be allowed to appeal? And to me, this is completely outrageous that you get a absolutely asinine judgment, and then in order to appeal the judgment, you have to come up with the money, which is asinine in the first place. I mean, to me, it's really, really wrong. I mean, there ought to be some kind of a constitutional case there, I would think, perhaps under the Eighth Amendment. But anyhow, getting back to the more relevant issues here, there's the 4 criminal trials and what's happening. The really big development that's occurred is that the Supreme Court, of course, decided to hear Trump's immunity appeal, because the appellate court had ruled unanimously with a 50-page ruling that in fact the case should go forward and that he doesn't have immunity in this case. And so I think, so that's where we are. And the fact that the Supreme Court took the case is actually very positive, I think, for Trump in a couple of ways, has been discussed. Of course, it's hard to know what exactly is the thinking here. I mean, if you're going to rule against him, why take the case? You had a perfectly well-written argument for the other side, unanimous from the appellate court. All they had to do is simply decline to hear the case and let the trial go forward in D.C., and everything's good to go, right? But and not only that, but then they decided that they're going to hear oral arguments on the week of April the 22nd. Which is quite a ways away. I mean, if they were going to really expedite this thing to get the trial on board, they're not doing that. And so on the negative side, it only takes, I believe, 4 justices to rule that they're going to hear a case. So you don't have to have a winning majority to rule a case. So if 5 people were agreeing with the appellate court and 4 disagreed, then, well, there you go. It wouldn't change the ultimate outcome, but even that could be okay. Although it's interesting that the scheduling is like it is, which, of course, they have a lot on their docket, but I would think the presidential election would be kind of important. So I think there's room to be somewhat optimistic that maybe he will get a win here. And I think that the case in D.C. case is completely bogus, by the way. So totally without merit, in my opinion. And there's also another case which comes out of the January 6th prosecutions of the various people involved in the, I guess you call it a riot, I would say, or whatever, or maybe just a protest that got out of hand or whatever. But mostly peaceful protest, right? But at any rate, this was using some particular arcane part of Sarbanes-Oxley, which is a financial business-related ruling, and they're also going to rule on that. Which, if they overturn that ruling in those other cases, then it would also kill 2 of the charges against Trump in the D.C. case. So I don't know. It's looking like we're going to prevent an early conviction, which is what I thought might actually derail Trump's campaign in some of the previous videos. So if that doesn't happen, and generally speaking, people are talking about, well, the end of the session around June the 30th or very early July will be probably when you would get the ruling from the Supreme Court, which would then mean they'd have to then go back, assuming it was unfavorable, and go ahead and schedule the hearing, which would then take time, and then they'd have to have the trial. By that time, you're probably running into the, we'll get into that later, but there could be conflicts in these different trials. Okay, so if you like this video, please give me a like. If you haven't subscribed already, please do. If you have subscribed, that's great. And you can also click the bell for notifications. So, yeah, and so that's that. Now, the other thing that's pending, which is another kind of obnoxious case, is the New York case over the financial records issue, which should be a misdemeanor, but somehow they've conflated into a claimed felony. At any rate, that's going to begin on March the 25th, and that probably will happen. And I have no idea what's going to happen there. Usually, assuming he has a judge as asinine as the one in the civil cases, it would look bad. But then again, I don't know. This would be a jury trial. So all it takes is one strong Trump person on the jury that doesn't get detected and kicked off the jury, that develops a strong case of reasonable doubt, and we could maybe kill that right there. Or if it has a judge that has any decency, he would throw the case out because it's bogus, but I'm not counting on that. But anyhow, that will be going forward, and I don't know if a conviction in that case occurs. Obviously, that it will be appealed, and I have no idea what's really going to occur with respect to that. I mean, ultimately, I think it's going to get struck down, and there is quite a time to have an appeal, obviously, in that particular case. So we'll see how that one goes. Now, then we move forward to Fannie Willis and the Georgia situation. It looks to me like that a pretty good case has been presented for the appearance of impropriety there. And remember, you don't have to prove impropriety, you just have to have the appearance of it. It appears to me like it's a completely political case by people that are kind of, obviously breaking the rules themselves, and have coordinated with the White House as part of a political effort to interfere with the election process. So, but we'll see. As I understand, the judge in the case is somebody who was appointed by the governor. I guess he's a Republican. I don't know. On the other hand, if he rules favorable to the Trump position, he may very well not be able to get actually elected if he's running for election in that particular county. So we'll see how that goes. But I think that one, tentatively, I'm optimistic on that. But these things, you never can get too optimistic. So let's move on to Florida, the Florida documents case, which I've covered a lot. I've said a lot about that one, which is, I guess, the case of Trump's blunders, I might say. I mean, this whole thing should have never happened if Trump had simply had the kind of legal advice he can obviously afford and would have taken it. But at any rate, here's where we are practically speaking. The case was supposed to happen in late May. And now both Jack Smith, the special prosecutor, the corrupt special prosecutor, and the defense both say that the case needs to be delayed, so they need to have time to prepare for it. And I believe that Smith is going for something like the 8th of July, I believe, is when he wants it, and Trump wants it after the election, of course. And he says the earliest he could be prepared to be August the 12th. Which, of course, would have the effect that they both estimate that their cases will take about 5 weeks each. So it'd be a 10-week trial, which would basically extend pretty much through most of the campaign season, with Trump being off the campaign trail in a trial, if it goes forward on the date that he says the earliest he could be. And if it was done earlier, it would still go through the convention and through the early part of the campaign, and probably have a verdict only when and right in the middle of the campaign, and only when it would be too late, probably in some states, to replace him on the ballot. So that would seem so if they go with that approach, it would look to me like they're clearly setting up for defeating Trump with a legal action. So I mean, we don't know what the judge is going to do because she, while being a Trump appointee, is under a lot of scrutiny as to see the liberals claiming she's biased favorable to Trump. Although there's no real evidence that up to date. She's kind of ruled a little bit this way and a little bit that. So that's hard to tell. And of course, no matter what's decided, there probably will be an appeal, maybe. Particularly, I think Trump will probably appeal to try to delay the case until after the election somehow, I think. And of course, the prosecutor wants to speed it up because his whole purpose is more than anything else is to defeat Trump, obviously. I always say it's funny when they talk about that you can't have the appearance of impropriety. We have impropriety all over the place here. But at any rate, whatever. That's lawyers. But anyhow, so that's the situation on that. And of course, as the merits, as I understand, Trump's primary defense is that the Presidential Records Act, that these documents, while highly classified in many cases, are covered by the Presidential Records Act, and as such, they are that should be the dominant rule of the Presidential Records Act, not the security law that was passed, I believe, back in the 1930s, which covers classified information. And some of the other laws, I think, were even earlier. One of them even goes back to, I think, World War I. And so anyhow, as I've pointed out in previous times, and I do feel that Trump really walked into this when he shouldn't have. All he had to do, I mean, this was so simple. I mean, he did not pack the documents, okay? All he had to do was simply say, I don't know if I have them, but if they are classified, do I have clearance to actually look at them? And then basically, let it go at that and invite people from the National Archives that do have the clearance to come in and search through things to see whether or not he had any of them. He didn't pack them himself, so he could probably be totally exonerated that way, right? That would be the argument. But no, he didn't do that. No, he didn't do that at all. No, he refused to turn them over, and then the thing got even worse because he did look at some of them, and then the FBI looked at some of them, and then the FBI double-crossed them because they said all you'd have to do is just make sure that there's a lock on the door where the ones are stored. It's complex, but obviously this ultimately was a setup, but he helped to set up a little bit. I mean, I don't understand what the whole thing is here. I mean, because even if they were turned over the archives, he could still make motions to actually have access for, creating any kind of memoir he might want to do. And I don't think he's in the mood to do a memoir right now anyhow because he's busy in a campaign. But, but at any rate, this whole thing could have been handled in a totally slicker way. But worst of all, he had lawyers that double-crossed him. They actually took notes of him making statements like, they're my documents, I don't want to give them up, and so on and so forth, which proved that he knew he had them and he knew what he... It's a mess. And then there's always the claim about, when he took things outside of secure areas, that he automatically declassified them. It's a mess. And I don't know how this is going to end up. If it's treated like the way it would be treated like any other person that, say, had a security clearance that somehow left their job with a bunch of documents, and if you're not Joe Biden, I think that you would probably just, they'd be in real trouble. But here you have the precedent of Joe Biden. And the only reason, but they kind of winged it by saying, well, because he's a man of, an old man that isn't thinking too well, no jury would convict him, especially no jury in D.C. full of Democrats would probably, right? At least one person would say not guilty, I guess. And so anyhow, so that's that. And but anyhow, so this will be interesting to see how this is ultimately tried. I mean, obviously. If they rule the Presidential Records Act supersedes the other thing, then we have obstruction because there was, documents were moved and there were things about, what he said to workers there, and one of them I think got indicted too for obstruction, and the lawyers, some lawyers he had at any rate, signed some paper saying everything had been turned over when obviously over 100 documents were later found in the FBI search. That's a mess. But it would be desirable to see if we can kick that one to after the election, I guess, if we can. And so I'm a little more optimistic than I was earlier because it looks like with all the delays and maneuvers and appeals that will probably occur before a trial really occurs, the key thing is to prevent it from going to trial to after the election. In which case, if we can win the election, at least we have I mean, there's different things that could happen then. And it would depend on, the trial probably couldn't be completed until he was in office, and maybe his new attorney general would drop the charges then. And I don't know how the judge would react to that. At any rate, they could fire maybe they could fire Jack Smith from the case and put somebody else in there who would drop the case or whatever. I mean, that's the key thing is to get past the election, and we'll deal with that then. Hey, the worst case scenario is vice presidential pick, right? Could be the president. So at any rate, it keeps the Democrats out. So that's the key objective here, of course, as I point out in many other videos. The Democrats have some really nefarious plans for our country here, and if we don't keep them out, some bad things are going to happen. So anyway, that's kind of the summary of where we are right now, and the things that are left to decide. The judge in the Georgia case and the judge in the Florida case are still haven't decided yet, and they're going to take some time to think it over and come up with their opinion, or their decision, I guess you'd say. And so, anyway, that's about that for this one. I'll of course be posting this on YouTube and on Rumble. The address of Rumble is, of course, will be in the description below, along with the addresses of my social media. So until next time.